everyone. So, it's our pleasure to introduce our distinguished visitor speaker today, Professor Tamara Buckwold from the University of Alberta's Faculty of Law. And Professor Buckwold began her academic career at the University of Saskatchewan and then joined the University of Alberta in 2005. She publishes and teaches in the area of commercial law and contracts and is the recipient of the Faculty of Law T.V. Miller Teaching Excellence Award. She's active in law reform and led the Uniform Law Conference of Canada project on reform of provincial fraudulent conveyances and fraudulent preferences law. And if you don't know what that is, take Bankruptcy and Upper Year. This is my little plug. She's the primary author of both the ULCC Uniform Reviewable Transactions Act with commentary and the Alberta Law Reform Institute report on reviewable transactions. And she's also co-authored reports that led to reform of Saskatchewan judgment enforcement law through the enactment of the Enforcement of Money Judgments Act. She's also contributed to a recent report on Canadian personal property security law. And if you're interested in personal property security law, which you probably will be after this talk, take commercial law with Professor McPherson as well. And Professor Buckwold is also active in continuing legal education and has presented at the National Judicial Institute seminars and various legal education programs for lawyers. She's the former chair and longtime member of the board of the Legal Education Society of Alberta, which delivers the bar admissions program in the province of Alberta. So without further ado, I'll turn it over to Professor Buckwold.
Thank you very much, Professor Torrey, for that kind introduction and for all you've done to make my visit so pleasant. Thanks to the Speakers Series Committee for inviting me and not being frightened off by the topic of my talk today. And thank you for all of you finding an hour in what I know is a very busy time of the year to be with me today. So I'm going to try and answer three questions today, at least in part. First question is, what is commercial law? Second question is, why is commercial law important? And thirdly, and most of all, why is commercial law interesting? Now, my first mission is to correct what I perceive to be a common misunderstanding about commercial law, and that is that the term commercial law sounds inherently business-like, right? So people in general, and law students in particular, tend to think that commercial law is all about the law of business. That in turn frequently leads people in general and students in particular to confuse commercial law with business organizations or corporate law, which is actually a very different thing, although many law schools, including mine, contribute to the confusion by grouping commercial law together with corporations law under the heading of business law. But the result of that misunderstanding is that in the minds of many, if not most law students, commercial law is the law of business, and that might just not be very appealing to you, although the people in this room are likely in the more interested than less interested category. So I may be speaking to the converted. But when I was in law school, I was that person, not interested in business law, not interested in commercial law. That's all about business, right? I found out sometime after I graduated that I didn't understand what commercial law was. Now, fortunately for me, I had taken the basic commercial law courses in law school, not through any insider wisdom, but because the Law Society of Saskatchewan in those days said, you ought to take those courses, which meant that we all took them because we all wanted articling jobs. All right, so I didn't have to build my understanding of commercial law from scratch, although I have to tell you I was not very far from scratch. So if you're not able to cover a lot of commercial law when you're in law school, don't despair, you can always start later. So what is commercial law if it isn't just business law? Commercial law is a pretty fluid term, and different people would put some slightly different things at the periphery into the box of commercial law. But I can tell you what commercial law essentially is. It's the law of transactions. Okay? So commercial law plays a role in every form of transaction, big and small, whether the players are gargantuan corporations or private individuals. If you went out and bought a coffee or some other beverage today, commercial law was there, hovering in the background. If you got a student loan, commercial law was for sure there. If you went out and you invested $1 million in the shares of some international corporation, it was there too, and good on you. Didn't happen to me today. Now, commercial law was not the only legal thing there, but commercial law was certainly the law that made all of those transactions possible, and it was the law that was likely going to be invoked if anything went wrong in any of them. Now, I acknowledge there was, you notice, there was likely a business at one end of the transactions I've just described, and that explains in part why people tend to think that commercial law is business law. But I emphasize again that the focus of commercial law is on the transaction, not on the parties to the transaction or the business entity that might be a party. And it applies equally to transactions between you and me as individuals, as private individuals. That's also the sphere of commercial law. So commercial law, as I'm going to talk about it today, is the law of transactions. What do we think of when we think of transactions? Well, I think the first thing that most of us think of is buying and selling things, right? That's a transaction. And in fact, the law of the sale of goods is a basic element of commercial law. But commercial law also includes all kinds of other transactions or dimensions of a transaction or things related to a transaction. And aside from buying and selling, probably the most common sort of transaction or event that characterizes our daily lives is one that involves the creation of a debt. Now, debt comes in many sizes and shapes, but it's everywhere. And when debt is created, it must also be recovered if it isn't paid. So a central part of commercial law, and the part that governs, that I'm going to be talking about today, is the law that governs various aspects of the creation and payment of debt. That's going to be my focus, so I'm going to ignore from here on in other important topics in commercial law like negotiable instruments and guarantees and the transfer of securities, and hopefully talking about debt is going to be more interesting than you think. So bear with me while I set the stage now. So that's what commercial law is. I'm now setting the stage for my second question: why is it important? All right, the law governing the payment of debt has two fundamental branches. The law of secured debt over here, which in this context we call primarily personal property security law, and the law of unsecured debt over here, which has two sub-branches. And those sub-branches are, you may be surprised to hear this, the law of judgment enforcement and the law of bankruptcy. The essential feature of all of that law is that it determines whether and how creditors can recover debt through recourse to their debtor's property. Here's a thumbnail sketch of those rights. So a secured creditor has an interest in the property of their debtor that gives them a direct right to essentially take it if the debtor doesn't pay, to sell or liquidate it, to pay off that secured debt. There is no court activity involved, at least when the collateral is personal property rather than land. All right? An unsecured creditor has no rights at all in relation to their debtor's property unless and until the law steps in to give them those rights. How might that happen? Well, first option, the creditor gets a judgment and invokes judgment enforcement law, and at that point and only at that point do they now have rights in relation to their debtor's property, rights that allow them to reach that property to recover that debt. So when I talk about in fact, a judgment is itself an unsecured debt. That's all a judgment is. So when I talk about judgment enforcement law, I'm really talking about the law that governs the ability to recover not only unsecured loans and credit, but any kind of claim in law that is realized through a money judgment. All right, so that's the first option. The second option with respect to recovery of unsecured debt is that the debtor goes into bankruptcy. And the trustee in bankruptcy then takes the debtor's property, it vests in the trustee, we say, and divides it up among the unsecured creditors after the secured creditors have pulled their collateral out of the asset pool. So, to conclude, that part, any legal relationship that involves a debt or a potential judgment for the payment of debt takes us into the realm of commercial law. All right. So why is commercial law important then? Well, maybe the answer is evident from what I've just said. Commercial law generally, and especially the branch that governs creditors' rights, matters in the legal universe the way the air around us matters in the physical universe. It is everywhere. Commercial law covers virtually all boundaries of legal practice, with the possible exception maybe of criminal law, maybe one or two others. Why? Because, as I've just said, under the doctrines of commercial law, debt ultimately becomes a right to the debtor's property. And many people with many kinds of claims will be competing for that property. So let's consider a simple story. Forgive me if the characters in my story happen to share your name. I try to avoid that, but you know, sometimes I get it wrong. All right, so Arda is the central character in my little story, and she is in financial trouble. Arda has some equity in her house, but she still owes quite a lot on a mortgage that's registered against the title held by a mortgage company, all right? 2 years ago, Arda bought a car from car dealer through an installment payment plan, under which car dealer holds an interest in the car to secure payment of the balance of the price. Arda also owes money to bank under secured loans taken out for various reasons. What does bank have? Bank has an interest in all Arda's present and after acquired personal property, that is everything except land, to secure repayment of that debt. Now on top of that, Arda has been sued by Noor, who fell and injured herself on Arda's icy sidewalk. That could happen in Winnipeg, I think, okay? Arda really has no defense to the judgment, so it's likely going to issue soon. Arda's in default under her loan with bank. She's barely keeping up the minimum payments on her Visa card, and she's a mess. So now the stress of debt has made Arda a miserable person, and so Kaya, Arda's spouse, has moved out. It happens. Arda has some income with which to satisfy her creditors, but not nearly enough. In addition to a little bit of equity in her house and not much equity in her car, she does have shares in a family company, and she's the beneficiary of a trust that was created some time ago by her favorite Uncle Buck. All right, if you practice family law, you could be consulted by Kaya, who wants to know what rights he has against Arda's income and assets, and your answer to that question will depend on the present or potential rights that can be asserted against Arda's property by the mortgage company, by the bank, by the car dealer, by Noor, and by Visa. You need at least a basic understanding of the nature of those competing claims and how they might rank against Kaya's matrimonial property or spousal property claim in a competition over Arda's assets. If you're a personal injuries lawyer, you might be consulted by Noor, who needs to recover compensation for the serious injuries that she suffered when she fell on Arda's sidewalk. That is going to depend on whether the judgment she might obtain can be enforced against Arda's property, and that will depend on the potential rights or actual rights that can now be asserted against Arda's property by the mortgage company, by the bank, by Visa, by Kaya. In fact, a good personal injuries lawyer, and I harangue my students about this, should be talking to Noor before they decide to litigate about whether a judgment they might get can be enforced, because otherwise, I'll tell you what will happen is if it can't be, your client Noor is going to be very unhappy about all the legal fees she paid to you to get to that empty pot of gold at the end of the litigation rainbow if she has a judgment that can't be enforced. Okay. And of course, if you're a business lawyer, you're going to be consulted by bank or Visa or the car dealer as to the rights against Arda's property, all of which is going to depend upon all of those other competing interests in that same property and how they're ranked. And that only covers a little small section of legal practice. Imagine you're an environmental lawyer and you need to know if a judgment against a big corporation for environmental damage can be enforced. That's going to depend on the rights of that corporation's secured and unsecured creditors. Or maybe you practice in a community legal clinic. Well, I'll tell you, debt is very often a problem for the poor. They might owe money to a payday lender. They might, God forbid, have unpaid student loans. They might face garnishment of their wages or seizure of their assets if they have any assets. They might face bankruptcy. And you can't help them very well if you don't know anything about creditors' rights. And so far, I've only talked about small-scale domestic problems. If you're working in international development, you need to understand commercial law, because commercial law reform is actually currently one of the primary tools that is being used to create economic growth and opportunity in developing economies. So I could go on, I'd love to go on, but I think you get the picture. I hope I've convinced you at least that commercial law is important and it matters outside as well as within the walls of business and big law practice. All right, so why is commercial law interesting? Now that's a harder sell, right? All right. As the title of my talk suggests, commercial law is often called black letter law. Why? Commercial law is all about rules. Many of them are statutory rules, so you can just imagine rules found in black letters on the white pages of the statute books, or more likely today in black letters against the white backdrop of the Queen's printer or a Canley web page, right? And to the extent that the rules of commercial law aren't in legislation, they are in the rules laid down in the judicial decisions that have been handed down over the last few hundred years by the courts. So it's black letter law. Commercial law is largely a rule-bound approach to solving problems as opposed to the sort of principle-based but more open-textured balancing of rights or interests that characterizes some other areas of law. So now, in the universe of legal intellectuals, to call someone a black letter lawyer might be a thinly veiled or not very thinly veiled insult. Okay? You see, these people know that.
No, we know nothing about that.
It may imply that the lawyer in question is a bit of a simple thinker. The assumption is that the black letter lawyer just learns all those rules, plugs in the facts, and spits out an answer. I'm a commercial lawyer, so that makes me a black letter lawyer, and I'd like to challenge that assumption. I should say, by the way, that the me that was you, that was an undergraduate law student a long, long time ago, would never have imagined that I would become a commercial lawyer. So why do I now love commercial law? Well, the answer lies partly in my little story about ARDA, right? Commercial law is practical and important. It makes the world work. It solves real-world problems. But more than that, it's conceptually interesting and challenging. Let's talk about those rules. Some of those rules are in modern statutes that govern some field of transactional activity in a comprehensive and integrated way. The prime example is the Personal Property Security Act, which we all know and love as the PPSA, which I'm going to come back to. Some are the rules laid down in statutes that are not very modern and in fact might have been enacted over 100 years ago. So for example, the Manitoba Sale of Goods Act of today is essentially the English Sale of Goods Act that was drafted by Sir Mackenzie Chalmers and enacted in England in 1893. It's the same act. Another example would be the Statute of Elizabeth, of 1571, which is pretty much what you have in today's Fraudulent Conveyances Act of Manitoba in slightly dressed up language, only slightly dressed up. And then we have all those rules established by the courts. So what, if anything, ties that all together? Well, contract law is a factor in commercial law because most transactions do involve a contract, right? Contract defines the rights of the people who are parties to a contractual transaction or relationship that creates a debt. But the essential thing in commercial law is not contract but property. Now, stay with me. I know property is not the favorite subject of everybody in law school, but the idea of property, if you allow yourself to think this way, is a kind of legal magic. All right? Property is what the law says is property. Property is created when the law says it is so. Property is that bundle of rights comprising this abstract thing we call property. It might be rights in relation to a physical thing, but it also might be a pure abstraction, like bank accounts or intellectual property, forms of intangible property. And the law uses this thing it has created to meet practical needs and solve problems in a reasonably predictable way through rules that are designed to achieve a policy objective. So commercial law is intellectually interesting and challenging because of the way it uses property. Now, first, it's our understanding of property that connects the different elements of commercial law and also connects commercial law with other areas of law like family property law, matrimonial property law. It's what we use to sort out the kinds of claims I described in Arta's story. It's because all of those claims are defined in terms of interests in property, all right? It's because of that that we can rank them using black letter rules. So a good commercial lawyer will consider the nature and scope of each of those property interests. They're not all the same. And then has to know either what rule applies to sort them out, or at least how to find the rule that applies to sort them out among that selection of statutory and non-statutory rules that I talked about. And that involves more than just an abstract exercise in applying rules. Actually, to be any good at that at all, you need to know why the rules work the way they do and what they're designed to do. All right, so that's the first reason that property is important in commercial law. The second is that, and this is the part I find really exciting, commercial law invents new ideas of property to meet real-world needs. So the property interest, maybe that's invented, is designed specifically to achieve a certain functional goal. And so we have function embedded in an interest, in an idea about property. And that's the special magic of commercial law. So the courts have been performing that kind of magic for a very long time. So for example, what is a debt? Now, in the mists of history, a few hundred years ago, a debt was only a personal obligation. So if I owed you a sum of money, you could take me to court to force me to compensate you if I didn't pay. But it was only personal as between you and me. But the law came to recognize that personal obligation, my personal obligation to you, has value, just like the gold under your mattress has value, okay? So that obligation became not just a personal obligation between you and me, but it became an intangible thing in the law. It became property. The law said that debt, wave the magic wand, that's property. And that means that you can transfer a debt to somebody else in payment, right? If you owe someone $100, I owe you $100, transfer my debt to them, pay the debt. You can give it to someone else. You can use it as a form of collateral for a loan, okay? So now maybe that's property law rather than commercial law specifically, but it's relevant to my point that what the law did there is it recognized the transactional value of a debt. And by a wave of the magic wand of the law, it transformed that purely personal obligation into a kind of property that can now be used as a transactional device. And then the courts developed these black letter rules around how that particular form of property can be used. All right? Now, more recently, commercial law has performed that same kind of legal magic on a much bigger scale. And that's going to take me now back to the Personal Property Security Act, which we call the PPSA. Every province and territory in Canada, other than Quebec, has a PPSA, and they're all pretty much the same. Some of you might know something or quite a lot about the PPSA, but I'm going to give a 30-second explanation for those of you in the room who don't. The PPSA is the law that applies to recovery of a debt where repayment is secured by an interest in the debtor's personal property as opposed to land, right? Personal property, tangible and intangible. So to give a common example, as in my story about Arta, most people buy cars using secured debt. Either a bank or finance company loans the money to buy the car and takes the security interest in the car to secure payment, or the seller of the car sells the car on installment payment terms and takes an interest in the car to secure payment of the balance of the price. In either case, if the debtor doesn't pay, the creditor then can, you guessed it, take the car, right? Sell it, liquidate it, use the money to pay off that debt. All right. And that would be inter-parties enforcement. But things get complicated if another creditor, say the credit union, has a security interest in that car to secure a different loan given by the owner of the car and secured by an interest in the car. That would be a priority problem. Now, those same basic problems and principles operate at all levels of transaction, from the simple car loan up to the mega billion financing of a big operation. So creditors take security interests in property, maybe of an enterprise, to secure supply debt, to secure loan debt. Those security interests, they're all in the same asset pool, or they may be. They're not always, but they may be. So they can clash and conflict, right? They have to be sorted out. Not to mention the claims of other creditors, like unsecured creditors, have to be sorted out. All right, that's secured financing, and that's the subject of the PPSA. All right, so now what's cool about the PPSA? Back to the legal magic. The PPSA created this new concept of property. They made it so by saying it so. The magicians who created this new idea, sadly, were not Canadian. The idea was created by the drafters of what's called Article 9 of the United States Uniform Commercial Code, but Canadian commercial lawyers and legislators latched onto the idea and adopted it in what we call the PPSA. So the drafters of Article 9 in the PPSA did this. They looked at the very complicated and inefficient system that was secured financing law in the middle of the 20th century, and they said, let's throw that out and create a system that is simple and produces functional results that we need in a predictable way. And they accomplished that by defining a new kind of property interest. And they called it simply a quote-unquote security interest. And that security interest folded all those old types of transaction that involved securing a debt through differing configurations of property rights into that one unitary simple idea. So a security interest is simply an interest in the property of the debtor that entitles the creditor to take that property and liquidate it if the debtor defaults, doesn't pay the debt. That's what it is. All right, so they defined this new property interest, and then they created black letter rules that established the rights that are associated with a security interest, how it's enforced, how you rank security interests as against other claims to that same property, which we call the collateral. Now, the main point here is that the wizards of Article 9 didn't just write up a bunch of complicated rules. Okay, they did that too, but that wasn't the main thing. They dreamed up this new way of thinking about property, and that was then the basis for this internally consistent set of rules or system of rules that responded to a real world need, responded to modern lending and credit needs, produced certainty and stability in a very important sector of economic activity. So to put it differently, they created rules that depend on and revolve around an idea about property. So the rules don't just say you can do this, you can't do that. They say here is a type of property interest. Is this one of those? And it performs a certain function, and here are the rules that tell us where that property interest fits in relation to other property interests in the same asset or asset pool. So now, that wasn't just an exercise in intellectual creativity by some law school eggheads, although they were actually law school eggheads, those people. But that system had enormous real-world consequences. We like to think our work does that sometimes. Article 9 in the PPSAs that followed it actually revolutionized the law in a way that benefits not just the big lenders and creditors and big companies and big high-priced lawyers of the world, but it benefits ordinary people by making credit not only more available, but available at a lower cost. All right, because recovery now, your ability to recover is predictable. And in fact, versions of that system, going back to international development, have been adopted in many developed and developing economies as a stimulus to economic growth, including micro-business growth. So to sum up all of that in a sentence, I would say the PPSA is an abstract system that translates into predictable real-world problem solving through the application of rules to an underlying concept of property. Now, recall that the PPSA is just one element in this broader map of commercial law and of law generally. So solving problems within the PPSA is one thing, and that's fun, and we like to do that if you're in that world. But we also have to use our understanding of property to solve problems that involve an intersection or overlap between the PPSA and some other area of commercial law or law generally. Again, it is property law that is both the foundation of commercial law and the glue that holds it together. So the Supreme Court of Canada has rendered decisions really only on 4 cases that involve the PPSA. It doesn't get very heavily litigated. And 2 of those 4 were actually companion decisions. They were kind of addressing kind of a similar thing delivered at the same time. I'm only going to talk about a couple of those decisions, but the reason I'm talking about them is because they illustrate my point. They illustrate the role of property in a commercial law problem. So the first Supreme Court decision was called Re-Giffen. It deals with how a PPSA security interest intersects with the system of bankruptcy law that is governed by the Federal Bankruptcy and Insolvency Act. Now, the decision depended first on the court's understanding of this new and different idea of property that was created by the PPSA, something the British Columbia Court of Appeal hadn't understood. Case I'm always very flattering in my speaking about the courts of appeal. Yeah, I'm kind of famous for it in my classes. All right, so the case involved the lease of a car. And the car was claimed by the trustee in bankruptcy of the lessee, the person leasing the car. And the lessor resisted and said, "You can't have my car." All right, who gets the car? Well, the BC's Court of Appeal, and I say with the greatest of respect, was stuck in old think. All right? It could only see the competing claims involved through the pre-PPSA characterization of the property rights of the participants there. And basically the view was that a person who leases a car to someone else owns the car, and there's no way that car could be claimed for unsecured creditors by the lessee's trustee in bankruptcy. The Supreme Court of Canada said, sorry, you just don't understand the PPSA. Under the PPSA, the lessor's interest is a security interest, and there is a black letter rule in that act that explicitly applies to this priority competition, and guess what? Apply the rule, the trustee gets the car. I could explain why that happened if you want to talk about it later. All right, and in a more recent case, which is a little bit harder to follow, called iTrade and Bank of Montreal, the Supreme Court of Canada dealt with the competing claims of a person who claimed a beneficial interest in corporate shares held in an investment account under a constructive trust. All right, so on the one side, so we have shares in a company in an investment account, and one party claiming them says, I am the beneficial owner of those shares as the beneficiary of a trust, a constructive trust. The other party claiming it was a bank who claimed a security interest in those shares, securing a loan given by the bank to the trustee, to the owner of the account. All right? Now, the lawyers who argued that case had to understand first whether creditor could have a PPSA security interest in property subject to a trust. And that required understanding how a security interest is defined by the PPSA, what that idea about property is. They then had to identify a black letter rule that applied to that competition between this PPSA security interest and the beneficial interest of a person claiming the shares under a trust. Well, there's no PPSA rule for that. So what did they have to look to? They had to look to the black letter rules of property law. And the rule that applied there is one you might or might not have heard of. It's the bona fide purchaser for value of a legal interest defeats an equitable interest rule. All right, so the bank gets the shares. All right, the companion cases I mentioned, I'm not going to talk about them, but what's kind of interesting about them is, again, the Supreme Court, or Justice Sharon, did this legal magic thing again. She was actually trying to solve a priority competition, okay, I'm going to talk about it, between a PPSA security interest in a farmer's farm equipment and a Bank Act interest in that farm equipment. Now, a Bank Act interest is a kind of secured credit, but a Bank Act interest as a property interest, as a property concept, is very different from a PPSA interest. And so we had this clash of interests, right? Who gets the agricultural equipment? And the court had to rely on, again, there was no PPSA rule that applied, there was no clear Bank Act rule. The court had to apply on property law, which was basically Nemo Dat. I'm sure you've heard that one, right? First in time, first in right. All right, but then the court had to say, well, what about agricultural equipment that this farmer doesn't own today, but doesn't know when he signed these agreements, but he's going to acquire sometime in the future? How can you rank property interests that don't exist yet under Nemo Dat, right? So Justice Sharada said, well, when that farmer signed each of those agreements, that gave rise to an inchoate property interest. Okay, I have a little trouble with this legal magic. All right, can you have any kind of an interest in property that you don't have yet? But never mind, I'm not in the Supreme Court. So again, that legal magic created this idea about property that the court then used and said, now we have these competing inchoate interests, we just apply Nemo Dat, okay? All right, so in all of these cases, though, it was necessary to understand concepts of property and the rules that apply to interests in property to solve this commercial law problem. And that's also true when you're dealing with the intersections between all the types of law that I talked about in Arda's story. The intersection between secured debt and judgment enforcement, the intersection between secured debt and bankruptcy, between bankruptcy and judgment enforcement, all of between commercial law and matrimonial property law or trust law. All right, now, so I'm almost done, and I want to mention, though, just one other dimension of commercial law that really interests me, and that's law reform. Professor Torrey mentioned that. I was fortunate to be directly involved in the creation of the new judgment enforcement law in Saskatchewan, which kind of did a little bit of a PPSA act. We said, out with the old, in with the new, right? We're throwing all that stuff out. It's all complicated and confusing. We're going to have this nice statutory system. All right, and I've also worked on another project, which she also mentioned, which is designed to replace the 1571 Statute of Elizabeth. Okay, but you know, you don't want to rush into those things. All right, those have been very fascinating but challenging exercises because they require thinking hard about how this new law should define the property interests on which you're hanging your rules, all right? What are the property interests, A, and what black letter rules do you use to define the rights that are associated with that? And you can't just think about the rules that only operate within this system, because you have to think about how that property interest is going to intersect with a PPSA security interest, for example, or some other interest. And is there a rule out there under the PPSA or some other part of the law that is going to conflict with the black letter rule you might put in this law, right? So law reform in any area, but certainly in commercial law, requires an understanding then of how this change fits conceptually as well as in terms of policy into the larger canvas of the law. You can't just invent untethered rules. The rules have to be anchored in the system of property law that ties the law together. So I think that, I mean, I don't know if anybody here in first year? A few? Okay. I'm told that some of you, I don't know if maybe all of you are considering the reform of a law that governs a person's rights to recover a debt arising from services in relation to caring for a horse. Is this true? Okay. Now, if you were imagining that law, you know, what do? Do you create a property interest in the horse to secure repayment? What kind of a property interest is it? What is it called? What kind of rights are embedded in that property interest? Is it restricted into the horse for which those services were provided? Or do you extend it to something else, maybe the saddle? When does it arise? What rights of enforcement does the holder of that interest have against that horse or anything else? Can they sell it? If they can, how do they go about that? What priority do those rights have in connection with some other competing claim to the horse? So, for example, a security interest held by the bank who loaned money to the owner of the horse and took a security interest in the horse to secure repayment of that debt. or possibly a judgment creditor of the owner of the horse who is going to have the debt seized to enforce a judgment. All right, so how do you define that interest, and how do you create the system of rules that both works within the statute and connects that statute with the rest of the law, okay? So I come to my conclusion, why do I love commercial law? I hope I've persuaded you that commercial law isn't just a matter of plugging facts into rules, although that is part of commercial law, and to be honest with you, that part is quite fun. You know, you plug the facts into these complicated rules and you get an answer, and that's kind of gratifying. All right, it's like doing this complex logic puzzle, but it is fairly complex, so there's some fairly sophisticated thinking involved in that. But more than that, commercial law does operate then at one level in this realm of pure abstraction, and another level in the world of very real consequences for very real people. It's about using concepts plus rules to produce predictable, workable, and fair results. So commercial law, here's my sentence. I'm trying to capture all this in a sentence. Commercial law is a structured way of solving real-world problems using contract, the conceptual underpinnings of property, and a system of rules. So I came to commercial law by a path I did not anticipate when I was in law school, but many legal careers follow that kind of winding and unpredictable path. Where you end up is very often the place that actually suits your particular intellect, your interests, perhaps your life circumstances, even though you might not have seen that destination when you started the journey. It turns out that my particular intellect likes to sort of sort out complicated problems involving abstract rules. Now, my advice to you is to keep your mind open to possibilities you might not have considered, and don't discount actually any area of law as something not worth knowing about without understanding what it is. And certainly don't believe them if they tell you that commercial law isn't interesting. Now, I can't imagine that you have any questions arising from that, but if you do, I'd be delighted to answer any of them. Oh, there are questions. Okay.
Thank you very much, Professor Buckwold, for a very comprehensive